under the heading minutes, whether the concept of parliamentary / legislative privilege as it stands today needs to be further refined, if not altered.
Yes.
D. Subheading D towards the bottom of page 12. The need to further refine the already refined concept of parliamentary / legislative privilege may be viewed from three standpoints. A. The law of judicial certainty and stare decisis. B. Parliament's views on this matter. C. The unintended consequences which may arise as a result of amending the law by judicial interpretative tools. Now, on this aspect of judicial certainty, I've culled out the principles and I'll cite 3 or 4 cases, just the relevant parts. It is a well-settled principle that law should not be unsettled merely on the ground that an alternative view appears to be more reasonable. A judicial precedent cannot be set aside unless A. Certain patent aspects of the question had remained unnoticed and the attention of the court on the previous occasion was not drawn to any relevant and material statutory provisions or judicial decisions. B. There was an error in the previous judgment, provided the error had a serious impact on the general administration of law. C. The previous judgment has not been consistently followed in subsequent decisions. That doesn't apply here at all because this has held the field minutes for so long. D. There has arisen a social, constitutional or economic change since the pronouncement of the previous judgment, necessitating a change in judicial stand. There can be a sea change in thinking, as in the 377 case, or in the context in which ADM Jabalpur was overruled. It was a complete change in thinking. There has been no such, there is no such need in this case as what I am going to submit, since political corruption was a phenomenon very much prevalent from 1967. Ayaram and Gayaram came in 1967. It's not a recent phenomenon. Now, 3 or 4 decisions. Keshav Mills, para 23. Sentence starts, but different considerations must inevitably arise, because earlier was whether you can set aside a judgment of the High Court. So obviously different considerations apply, but different considerations must inevitably arise where a previous decision of this court has taken a particular view. Justice Pardiwala has got it,
Which paragraph are you?
Para 23, at page 294. Thanks.
It starts
in dealing with the question. That's right.
As to whether the earlier decisions.
That's right. That's right.
Correct.
Then, I'm taking my lord straight to the middle of the paragraph.
Okay.
But different consideration must inevitably arise where a previous decision of this court has taken a particular view as to the construction of a statutory provision, as for instance, section 66(4) of the Act. When it is urged that the view already taken by this court should be reviewed and revised, it may not necessarily be an adequate reason for such review and revision to hold that though the earlier view is a reasonably possible view, the alternative view which is pressed on the subsequent occasion is more reasonable. In reviewing and revising its earlier decision, this court should ask itself whether, in the interest of the public good or any other valid and compulsive reasons, it is necessary that the earlier decision should be revised. When this court decides questions of law, its decisions are, under Article 141, binding on all courts within the territory of India, and so it must be the constant endeavor and concern of this court to introduce and maintain an element of certainty and continuity in the interpretation of law in the country. Frequent exercise by this court of its power to review its earlier decisions on the ground that the view pressed before it later appears to the court to be more reasonable may incidentally tend to make law uncertain and introduce confusion which must be consistently avoided. That is not to say that if on a subsequent occasion this court is satisfied that its earlier decision was clearly erroneous, it should hesitate to correct the error. But before a previous decision is pronounced to be plainly erroneous, this court must be satisfied with a fair amount of unanimity among its members that a revision of the said view is fully justified. it is not possible or desirable, and in any case, it would be inexpedient to lay down any principles which should govern the approach of the court in dealing with the question of reviewing and revising its earlier decisions. It would always depend upon several relevant considerations. What is the nature of the infirmity or error on which a plea for a review and revision of the earlier view is based? On the earlier occasion, did some patent aspects of the question remain unnoticed? Or was the attention of the court not drawn to any relevant and material statutory provision? Or was any previous decision of this court bearing on the point not noticed? Is the court hearing such plea fairly unanimous that there is such an error in the earlier view? What would be the impact of the error on the general administration of law or on public good? Has the earlier decision been followed on subsequent occasions, either by this court or by the high courts? And would the reversal of the earlier decision lead to public inconvenience, hardship, or mischief? These and other considerations must be carefully borne in mind whenever this court is called upon to exercise its jurisdiction to review and revise its earlier decisions. These considerations become still more significant when the earlier decisions happen to be a unanimous decision of a bench of 5 learned judges of this court. Of course, this particular decision is not a unanimous decision. Then,
But Mr. Ramchandran, in your formulation in para 15 of your written submission,
Lordship, please, Manoj.
you say a judicial proceeding cannot be set aside unless, and
Yes.
then you sort of break up all the questions which are raised by Chief Justice Chandrachud into A, B, C, and D.
Lordship, please.
Now, what the judgment in Keshav Mill lays down are illustrative
Lordship.
of when a review can take place or revision can take place, as they call it. They're not exhaustive.
No, they say so much. That line, I read out that line which says it's not possible to give a complete. Yes, Manoj.
And above all, they emphasize the aspect of public good.
Lordship,
What
please,
is
Manoj.
it for the polity?
I bow to that, Manoj. And I am going to submit, when I come to Narasimha Rao's judgment, that this court was the majority itself was very conscious of this concept, Manoj, of public good. And that's why, in spite of our sense of indignation, as the expression used, it is not that the court was oblivious of that. Rule of law was, after all, Manoj, and is always an overarching consideration when this court decides any constitutional issue. Manoj. There's nothing which the court lost sight of, but the court weighed and then preferred the view which the court felt the plain language of the Constitution warrants.